Start. The auction of the property was held on 14/2/2013. The appellant herein was highest bidder. He deposited the earnest money and then 25% of the auction amount. The appellant finally deposit the balance amount of the auction price on 13th March 2013. He was intimated regarding confirmation of sale by the authorized officer of the secured creditor by later dated 27th February. According to the appellant, he deposited 75% of the balance amount within 15 days of confirmation of sale. The principal borrower, whose property was sold in auction, questioned the auction sale by filing a writ petition. The division bench of the High Court directed the respondent herein to file an appeal under Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002. An appeal was filed. The Debt Recovery Tribunal set aside the sale. The order was confirmed the Debt Recovery Appellate Tribunal as well as by the single judge and the division bench of the High Court. Now, this appeal before the Honorable Supreme Court by the auction purchaser para. Point for consideration is whether the period of 15 days would start for making the deposit of remaining 75% from the date of communication of sale or from the date of the auction para. Held Rule 9 within bracket 4 makes it clear that balance amount of the purchase price payable shall be paid by the purchaser to the authorized officer on or before the 15th day of confirmation of sale of the immovable property or such extended period as may be agreed upon in writing between the purchaser and the secured creditor. Thus, Rule 9(2) makes it clear that after confirmation by the secured creditor, the amount has to be deposited. Rule 9 within bracket 3 also makes it clear that period of 15 days has to be computed from the date of confirmation. In this case, confirmation has been made and communicated on 27th February 2013 and within 15 days thereof, that is on 13th March 2018, the amount of 75% had been deposited. Thereafter, sale certificate has been issued under Rule 9 within bracket 6. Rule 9 within bracket 5 also makes it clear that in default of payment within the period mentioned in Subrule 9 within bracket 4, the deposit shall be forfeited. There cannot be any forfeiture of the amount of 25% in deposit until and unless the sale is confirmed by the secured creditor and there is a default of payment of 75% of the amount. The interpretation made by the High Court thus cannot be accepted. Para. If we read the provisions otherwise, then we find even before the confirmation of sale within 15 days, the amount would be forfeited by the authorized officer who may decide not to confirm the sale. That would be a result not contemplated in Rule 9 within bracket 2, 9 within bracket 4 and 9 within bracket 5, which fortify our conclusion that it is only after the confirmation is made under Rule 9 within bracket 4 that amount has to be deposited, and on failure to deposit the amount, 25% amount has to be forfeited and property has to be resold. The provisions of Rule 9 within bracket 6 also fortifies our conclusion inasmuch as it is the expression used that on confirmation of sale by the secured creditor and if the term of payment has been compiled with sale certificate is issued, otherwise the forfeiture takes place. This compliance has to be only after the confirmation of sale and not before it. Thus, various provisions of Rule 9 makes it clear that interpretation made by Debts Recovery Tribunal and Debts Recovery Appellate Tribunal and as affirmed by the High Court cannot be said to be correct. Stop.